Hello everybody, this is Attorney Shah Parali, and today we're going to bring you an update on the cap gap students and also on a lawsuit that has been brought under unlawful presence. It seems that there was just before I start, let us go into the updates for students. What are we getting for those who are still on cap gap and still waiting on their answers from the USCIS? Well, unfortunately, it seems like some people are getting approvals. We got few people who got approvals, but I got few consultations where people were denied because they used the over 1 year of CPT. And that's becoming really kind of a headache, because that can also mean that down the road, people who are filing transfers, extension, they might come back and say, hey, you also use more than 1 year of CPT, and it's not fair, because basically if you use more than 1 year of CPT, they ultimately are denying people with some cases, right? Not all. They're denying them their H1B, and that means also H1B extensions and also other kind of not only the H1B extensions but other benefits. The part which is unfair in that the overuse of CPT, the punishment is usually basically taking away the OPT, but not really kind of completely taking away the H1B, plus putting people on that memo of unlawful presence, saying there's a violation, which ultimately results in unlawful presence from the date of overusing the CPT. And that's where it brings us to that lawsuit, which was brought by, I think, Anza College and some other school. And they are basically talking about how unfair the system is in that lawsuit. And this is not the normal process. For me personally, it's becoming kind of some kind of ex post facto law. Basically, for example, if you base yourself on the unlawful presence memo of F, M, and J students, what it does is that if you committed a violation where there is quote unquote you were not guided by your DSO that this was a violation, you overused CPT, or you missed on an OPT, you filed an OPT 1 day late, etc., etc., you are getting punished from the date of that violation, which is not really the real intent when the student visa, the DS, which is a duration of stay, duration of status that is on the DS. If you look at your visa, usually for student visa, there's a DS, which means duration of status. That means as long as you maintain status with your I-20, etc., you are in status. But with that unlawful presence memo, what it does, it basically brings you back in time and gets you in a situation where if any kind of violation, you will be punished from that date. So it is kind of very, very unfair what we are seeing right now, and that lawsuit is long due. And I hope that the federal court the lawsuit is being brought, I think, in Northern Carolina federal court, if I'm not mistaken. And ultimately, it is a situation where many people are really kind of upset on the fact, not only upset, but it's causing really a big disturbance. And the lawsuit is in the district court for the Middle District of Northern Carolina, which basically for people on the Ninth Circuit would not really be benefiting from it. But at least if one lawsuit goes through, hopefully other schools will bring the similar lawsuit here in California, and ultimately we're going to see some kind of changes on this rule and in the decision from the court. And what we expect is that usually if the court gives a decision, then ultimately the memo gets amended by the USCIS and to reflect that lawsuit. And that's what we are hoping will happen here. And the lawsuit is being brought by Guilford College, Guilford International Club, the New School, Foothill-De, Anza Community College, and Haverford College. And that's against the Department Kirstjen Nielsen, which is the head of the U.S. Department of Homeland Security, and Francis Cissna and the USCIS. So the lawsuit is being filed in in basically the federal court. So according to the complaint, the plaintiff Guilford College International New School, Foothill-De Anza, and Haverford College bring the complaint against Kirstjen Nielsen in her official capacity as a Secretary of Homeland Security, and other people also, Francis Cissna, etc. And they allege that the because of the world's leading college, that they allege a lot of points. I think it's like 75 pages. I have put it here. You will see it on the screen, but I'll hopefully put a link to it. And they believe that the unlawful presence is totally unfair and is kind of going against what has been is departing actually from what we have seen in the past, and that's something that we've been saying. But now at least there's a lawsuit to bring that, and then they mentioned that there's a vast majority of students that come to the United States on M, F visa or J visa, and there's no date on those visas. It's just a DS, which is a duration of status, and they also mentioned that for many years, the United States have not held unlawful presence against students unless an action was taken by the USCIS to take away their status. And this has been always the thing with student visa. Even though you had some kind of violations, your status was not going away and you don't accrue unlawful presence. The problem with unlawful presence, if you accrue more than 180 days, and in case you have to reset your status, you leave the country, they will block you under the 3-year bar rule. And that's what the lawsuit is also mentioning here. And also we are talking about it is a violation according to them. The whole thing violated the Administrative Procedure Act, because they didn't ask for public comments. They just went ahead and changed the rule without going to that. I'm not sure is going to fly, but again, let's see. And also they mentioned that the concept of they have changed the whole concept of unlawful presence, and ultimately violated what we call the due process clause of the U.S. Constitution, and then it basically also mentioned that the Constitution forbids such unforeseeable and arbitrary government conduct, which is true. And also now going on that entire thing, then they will go on, and you can read it, and that they are basically asking for relief, and they say they have jurisdiction, venue, and they basically they cover what is an F visa, M visa, etc. And they say also one thing which is important. They mentioned that 1.2 million individuals were on student visa in 2018, and 400,000 of which are enrolled in bachelor's degrees program, and others were seeking master's degree. And as you know, many people who came also took a CPT, and that's where a lot of problems are starting, the CPT, and also the OPT extensions, any small violation, or CPT, anybody who took CPT twice, basically more than 12 months, or took a same education level CPT, are getting punished basically, and are getting their H1B. Not only getting their H1Bs denied, but they might have been accruing unlawful presence from the date. And that's what the update is about the situation right now with the USCIS. We are seeing that there is a huge kind of influx of cases where basically those cases are being denied on those grounds. So students who have used CPT, or basically what they call it abuse CPT according to them, are going to get a denial, although it's a case-by-case basis, of course. But again, this lawsuit might protect that, because the unlawful presence is one issue. The second issue, using CPT more than 12 months. And as I mentioned before, I think a couple of years back, I told people to avoid overusing CPT. CPT is not meant to be a work permit. It is a curriculum practical training. It's used under special circumstances. But unfortunately, some schools have seen fit that they will just issue CPT right and left. And this is why we are seeing many of those problems coming up right now. So bottom line, this lawsuit combined with what's happening to students who are on cap gap is kind of going hand in hand, because it will be affecting them to a high extent. Number one, H1B gets denied, but worse, they can get barred for entering the United States at a later stage. And even if, since most of the time people have taken CPT 1 year ago, they are not even eligible for reinstatement, etc., etc. So the options out there are not many, unless we see that unlawful presence memo going away, and we saw them not kind of overusing, basically taking advantage of the situation where there was a misunderstanding. And the other thing that they mentioned in the lawsuit is that the students, the DSO themselves, the DSO, as you know, is a designated school officials. They are supposed to kind of represent the government in the school. They themselves have wrong information, and what do? They have advised people to, you're okay to take a CPT, you're okay to do this and that, and now suddenly they are seeing themselves completely confused. And in fact, I get a lot of calls from students where the DSO told them, go talk to a lawyer because we don't know anymore. And that should not be the case, because the DSO should know. Unfortunately, it's not that they don't want to know, it's just like the whole thing is so confusing. They gave you an advice, quote unquote, to go and take a CPT, or they give you an advice to use your OPT, and then suddenly you see them getting an issue of, you are in unlawful presence, you're getting your H1B denied. And there are many people on cap gap. Some are getting approvals, by the way, so don't think everybody is getting denials. But the truth is that we are going to see more denials than approvals, definitely, because of, for those especially who have used CPT or overused their OPT. I'm losing my voice here. So I wanted to let people know that we'll keep you updated what's happening on the cap gap, but it's coming on a dripping kind of. It's almost like a drip irrigation system. I always compare it to that. So we are getting some cases one by one. Some are getting approved, some are getting denied. Not mostly from our office, because we have most of our cases were approved before the October, but many people are calling me on consultations and asking me, Shah, what's going on? What do I do now? My H1B got denied. I was on cap gap. Well, you don't have much of a choice. The question is that, can you move back to student visa? Probably not inside the US. You will have to leave the country, get an approval, and then go to the stamping and come back, because if they apply the unlawful memo, unlawful presence memo, that means basically you probably got your status cut off earlier if the denial is based on that. Of course, the denial can be based on other reasons like a specialty occupation, etc., etc., employer-employee relationship, which is another issue. But if it is based on overuse or an abuse of a student visa, or a not maintaining your status, then you might have a problem, because unlawful presence will become an issue. Give me a call. Let us assess your case. 510-742-5887. And anything I told you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. Please subscribe to our channel and tick on the bell so that you get updates, because that's the only place I'm putting updates right now. I barely have time to write articles. So good luck to you. Phone number 510-742-5887, and the website attorneyonair.com. Attorneyonair.com. Thank you.